Got it. All right, so I think that we're pretty well live. We do have one other person that's joined us in the meeting room, but it's basically, I'm Casey Manhennick. I'm a realtor with eXp Realty, and I'm here doing a Zoom info session with Whitney Maher. That's right, how I say your last name?
Maher.
Maher, okay.
Yeah.
And Whitney is with Kate's Ford, Soll and Epp, barrister and solicitor in Kamloops. But one of the reasons that we're gathering here today is, as many people know, my home base is in Ashcroft, and I do service many of the rural communities, and I've always been a strong advocate to bring resources into the smaller towns. So Kate's Ford, Soll and Epp started coming to the Ashcroft office location now every Tuesday, and we have 3 different lawyers that are coming on a rotational basis. And maybe Whitney, I'll let you tell us a little bit about the services that you're able to offer both in Kamloops and then at the satellite offices in Ashcroft. And I know you go to Chase as well.
We do. So yeah, we have a Chase office that has been established for quite some time. It's just on Shuswap Avenue there. We essentially, I'm on the solicitor side of things. Our office generally handles pretty much everything. We don't have a specific employment department. We're not tax lawyers. So there's a few areas that we don't cover, but we are a general practice firm. I practice in wills and estates. So that includes estate administration and corporate matters, commercial matters, so buying, selling businesses, and real estate. So those are my primary areas. I also will draft agreements, contracts, and I also advise on residential tenancy issues.
Right. I know I've asked you several questions in the past on different tenancy situations, whether it was commercial or residential, because those can always be complex. And there's lots of tenants that are out there that often run into issues or have concerns. And it's always good to consult with a lawyer. Today, we're specifically looking around some of the services that have been popular, I think, in the Ashcroft, Cache Creek, Clinton, and even people coming over from Lillooet to meet you in the Ashcroft office. And I sort of wanted to talk about how wills, power of attorney, handling people's estates are connected with realtors, and some of the questions that we come across or situations we're presented with. So it's never fun to be in a more reactive situation. And my goal is sort of to educate the community as to why wills are important to protect yourself, your assets, and obviously your loved ones. And I'm sure we could go on for days and do multiple series on each topic, but we're going to kind of hit some general points tonight. I think I talked to you earlier about one of the scenarios I get, and as much as we don't like talking about death and people passing, and some people feel more comfortable about it than others. I think different generations feel more comfortable about sharing what their plans are. But I definitely have been involved in situations where apparently a seller is calling me to come in to do an evaluation on their home. And of course, as a real estate agent, we need to verify people's identity and be assured that they actually have the legal means to sell their home. And so sometimes it ends up being that it's been a husband and wife. They've lived in the home for 15, 20, 30 years together, but her name was maybe never on the title. And now he's passed and she can't afford to keep the house. What's the scenario? We've had different situations where we have an executor come forward that needs to sell a loved one's house as well. And of course, it can be awkward as an agent. I need to see the will. I need to know you can actually sell this house. And then again, power of attorney and similar roles that way too. So I was hoping that we could just sort of touch on some of those different situations, and maybe like to begin with, we could just talk about wills and why people should have one.
Right. I think everybody should have a will. I think some people think, well, I have a property, it's joint, so it'll go to my spouse when I pass, and why do I need a will? Or similar, or I don't have assets or something like that, right? If you pass without a will in BC, somebody is going to have to apply. Probably one of your loved ones will have to apply to the courts to be appointed a minister of the estate. And so it's like an executor. essentially, but when you're appointed by the court. And they're going to have to essentially distribute the estate to, it's essentially a list through law, but it'll be either to the spouse if there is one, to the children, otherwise potentially a mix of both. And then if there's no spouse or children, we go down to siblings and parents and from there. So which might not be what the individual wants. So it's important to have a will. So one, you can potentially look at avoiding having to apply for probate. That's not always possible, but that's something that I often discuss. Making sure that you have an executor that you trust and is going to be equipped to act. And the executor is the person who's going to find out what assets are in the estate, find out what debts there are that will need to be paid, and determine who the beneficiaries are. If there's a will, that should be fairly straightforward. If they have to apply for probate, they'll go through that process through the courts, and then they're going to distribute everything, deal with income taxes, deal with funerals, all those kinds of things. But so you want to have something that somebody appointed who's equipped for that. And you also might have specific wishes on where things go, right? And that might not align with how it would work by intestacy if you pass without a will. So will is important for everybody. If you have minor children, it's also important then, particularly important because if both you and your spouse passed, you'd want to have somebody appointed to be their guardian. That would be done under the will generally. So some examples of why you want to will.
Right. And I know like one of the questions, or actually it was a big awareness for me, because obviously we see more and more blended families owning properties these days. And truthfully for me, I have a blended family, and until I got into real estate and learned more about the different ways you can have title, I didn't realize that as joint tenants, say I passed, I couldn't will my share of the home to my children. It's basically right of survivorship, and it's going to go over to the other person who's on title to the home. And so I think educating people too when they're buying property about the different types of ownership and how you're going to hold your ownership in that property is really important, so that those wills actually are valid, and there isn't a big surprise in the end when you thought that your equity in your home was going to care for your children, when essentially it's locked in with your partner, whether it's a common law partner or a married partner.
There's a lot of issues around how you hold property. I think also, so it can be a good idea sometimes, right?
Right.
Spouses often, if they share assets and if they're not in a blended family situation, they have the same children, often it makes sense to have both of them on the property. They want everything to go to the other, right? And potentially, ideally, they avoid probate when one of them passes, because you can often avoid it in that circumstance, right? If we're just wanting it to go to your spouse. But it's not, that doesn't always make sense. And I think some people think, oh, well, we'll avoid probate, but don't really think that far through, understand what that means by putting somebody on joint tenancy. And that's the same for bank accounts, same for beneficiaries on RSPs or RIFs, different investments, life insurance, all these things that can be used as estate planning tools for avoiding probate, when you have to pay probate fees, all those kinds of things. So it is often something I talk to clients about. We set up often trust agreements to make sure that whoever is added on there is going to distribute things pursuant to the will if that's what they want. There's different reasons and ways we do that, but it doesn't always make sense, right? And it does take it out of the will. It takes it out of your estate. Whenever you add somebody onto joint tenancy, joint on bank accounts, as beneficiaries on those investments, the idea is that it will go directly to them. And so it's no longer in your estate. It's no longer governed by the will. So, and some people don't realize that for sure.
And I'm having a seminar, I think it's next Friday, with a wealth advisor that's going to talk about that when it comes to estate planning and everything. There's different kinds of wills though as well, correct?
There are. Yeah. The most, simple will is the kind of most common one we do, and that's variations of that. They can get, obviously degrees of more complicated.
Right.
Adding trusts into a will is one way they can get more complicated. And there are also various, you can have a primary and secondary wills and things like that. And that makes sense for people who have large or assets with large values. So for example, shares, if they have a company and they have shares in a company and they have large values, then sometimes they'll have different levels of wills to avoid probate fees on certain assets and things like that.
And it just kind of gets more complicated without the will, and the time stretches out into when you can liquidate those assets and potentially pay out your debts that are incurring interest while all of this is being sorted. And I know I have a situation right now where basically a will wasn't in place and none of the family wanted to stand up to take responsibility. And so it's basically sat there for almost 2 years, to the point where now the lawyers are basically recruiting somebody to please step in. So 3 provinces over, a family member is finally willing to help settle everything, but it's a much lengthier process. And in the meantime, we have to worry about what's happening to those assets in the meantime while we're waiting to be able to legally sell that home.
And probably decreased in value significantly now, I imagine, and legal fees have probably gone up in the meantime. And
yeah, exactly. There's not much of an inheritance left once we start deducting all of these additional expenses of just trying to get paperwork in order. And I guess for me, because I'm a mom, obviously my kids are all adults now, so I'm not in that crucial period where I was like revamping my will every 3 years or so, given whenever I had a major employment change or I changed houses or my kids grew up and moved out. Different scenarios could be amended. But we do run into a lot of people that they don't own a home, and so they don't think they need to have a will, but maybe they do have minor children, and maybe they're renting and they just assume that a family member is going to step up and take care of their kids. But on another side, it costs a lot of money to take care of kids these days and arrange for daycare and everything else. What happens in those situations?
So and that is one issue with that, which is whether they're actually willing to be guardians. So you should always canvass that with somebody you're appointing under a will. But also, are they actually, have they been appointed, or are they now going to have to apply to the court potentially to be appointed a guardian because there was no will appointing them as guardians, right?
So when we get into minor children, where we assume like we're a close-knit family and our family's grandparents, whoever's gonna step in and take care of these kids, because they haven't been given the legal authority as guardian, it means when it comes to school documents, immunizations, traveling, any of those things, it can't happen until it's gone through the court and they've actually been appointed as guardian. And I'm assuming family can contest that if they don't figure the person who's...
If there was some kind of competition between family, you could be in family court going through litigation on that, right?
And so basically, again, it's the kids who are sitting there unable to participate in school activities or have medical treatments done or... Right. Yeah. So things we don't really think about, like we think there's a family member that's going to just step in and take care of it all. So that's one scenario. I know that when it comes to wills, some of the other things I've had people mention to me that have been going through the process is just like living wills or living trusts. And so that they feel they have more control over their estate and how the family's going to be dividing their assets to reduce conflict, I think, within families potentially. Is that something you're seeing more frequently, or it's still more on the rare side?
I'd still say it's more on the rare side. There definitely is a difference between living will and living trusts.
Okay.
And I think we talked about this earlier, but I think when you say living trust, you're referring to testamentary trusts. So there are different kinds. Inter vivos is essentially when somebody's alive. So what I would think of living trust, but that is often more with setting up family trusts and spousal trusts and those kinds of things, which is sometimes when people have significant assets is what they will do so they can make sure that their family is cared for in a certain way.
And
but that's
Sorry, does it allow them to avoid probate as well when you've already put that in place?
Potentially, yeah, that
Yeah.
could, and that's very high level planning. It is something we do, but it normally is not something we do unless there are
Substantial assets that are
there.
involved, right?
Yeah, for sure. Testamentary trusts or the other kind, and that is a trust put into a will. So that actually doesn't take effect until somebody passes. And so, which can also be a good planning tool, particularly if there's, often I see with children where maybe they're in transition, or they have alcohol, substance abuse issues, something like that, where there's a concern about them receiving a large amount of money, or where there's they have a disability and they're receiving PWD, personal disabilities payments. And there is a limit, an income limit on how much you can have if you're receiving that benefit. And so it's a problem if you get a large sum of money from somebody's inheritance, all of a sudden, that either that person is then looking at having to set it up themselves, whereas otherwise it could be put into a trust and distributed, and that would kind of keep it exempt from, would allow them to continue receiving those benefits and still qualify.
I know.
So those are common ones I see in the will. But
I think, again, it's like when you have your own individual situation to review your will, you learn more and more about different areas you should assess. So I've had a will for a long time. I've revised it a few times, whether it's because I was divorced or I started a new career or I was sharing assets with a partner. But like, I know when we did my last one and we were talking about right of survivorship when it came to title, it's like, well, what happens if you're both in a car accident and one person just dies 10 minutes before the other? Well, what's going to happen then? Well, still the person who died last is the one who inherits the estate and their children, potentially if they've willed it.
potentially, I think actually it's generally, if it's joint tenancy, it depends on what the will says. But normally in our wills, it's essentially you're considered to have predeceased if you pass within 30 days. So even though within 30 days. So if it was right after the 30 days, then it would have to go into the next person's estate and go pursuant to their will, despite the fact that they may have been in the same car accident and you just survived 30 days longer. But if you actually passed at the same time, and it was held jointly, it would be considered 50% would go into each state, is how that would work.
When we were going through COVID, the courts really slowed down with probate, basically. And we had a huge backlog because we had quite a few homes sitting here waiting for probate to complete in order that we could legally sell it. And in some cases, it was over a year that we were waiting for probate to complete. I think we're more on track, but would you say if somebody has all their will in place and lined up and things are organized, that probate's what, 3 to 6 months now? Or
it's actually, so when we file it, it's taking the court 8 months right now on average to review it. No, and they actually, for a bit there, they were around more 3-4 months, and 4 to 6, and now it's more around 6 to 8. Now that's the Kamloops courts. So we have actually been filing in other courthouses, which are a bit faster.
Well, that's good to know that you can actually do that you can go outside of the Kamloops jurisdiction to do that if you're from the area. I think I was going to ask you, like, when a will isn't in place or the person passes that was on title, what happens to those assets? Everything's just frozen and the spouse that's surviving that wasn't on title has to wait for probate then? Yeah,
and one issue that can arise with that is if the property has significant value to it, like if we're looking at a home that's 500, 600, whatever, thousand, they may not be able to keep that home. There is how intestacy works is if there is a spouse and children, when that individual passes, the spouse gets a preferential share of 300,000. And then there's a division between the spouse and the children of anything after that. So I don't remember off the top of my head what the percentage is after that, but essentially they could potentially not, like, either be able to have to pay out to keep the home or things like that, which is another issue. It's everybody thinks that, it automatically goes to the spouse. Well, not always, right? Only up to a certain portion.
And I'm sure that can cause conflict if that spouse has lived there for 30 years and has invested, or they were, maybe it's their second marriage or whatever, and now that person that's remaining's invested a lot of money in the home as well. It's definitely an issue. I know I've had it a couple of times where I've seen life estates, which is something else altogether. I know it's fairly rare that we see it on title, but maybe you want to talk a little bit about what life estate is.
Yeah, so life estates, they can be registered. I've also seen them unregistered and they're still valid. It just doesn't freeze title or notify potential buyers in the same way. But essentially, most common it's for spouses, where, like you said, in a maybe divided family situation, the new spouse, non-biological children or stepchildren, and the individual passes, and they want to make sure that that spouse can continue to reside there because they have been for quite some time. And then after, whenever they want to leave, they may want to divide it between the children or between the spouse and the children or what have you, right? But so often it'll have conditions that the spouse has to pay the property taxes, keep the property maintained. Sometimes it'll say that if they get remarried, then they have to leave. But there's conditions that have to be followed. If they aren't, they'd have to leave, or when they want to leave, or if they pass. Normally, then the life estate is up. And at that point, there'll be something setting out what's happening at that point. Normally, it'll be sold, likely, and then the proceeds distributed perhaps to the children at that point.
Right.
So that's a common situation. I've also seen it for children. Sometimes if there's a child that potentially is residing in the home already, or would really like to, and they want to give them a place to live, there is a potential wills variation issue there as far as maybe giving a little bit more of an interest potentially to that child. But in the end, if you are giving everything left over or after the life estate ceases, if that's going to be divided between the children, then that's less of an issue potentially.
Other than the person that has the benefit to life estate, changing it by some of the conditions with getting married or moving away from the home, do they expire at all? Like, is there at any time where, unless you have it removed, I guess it's going to be valid on that title? And if you want to sell the property and somebody's registered with life estate, is there anything that we have to address? No.
Well, sorry. The first part, I was nodding no to the first part of that, which is it does not expire. You would need to address that for sure. I believe, so either, I mean, if the life estate's still going and they're living there, that's a big issue. But assuming that's not the case and it is actually ready to be sold, I believe that there would be, if you'd filed an affidavit or something along those lines.
Yeah, I would guess that you'd be looking for some sort of mutual agreement from the person that holds the life estate, stating that they've chosen to leave the residence, which then made it valid to sell under the terms of whatever the will was.
I haven't had to release a life estate before, but I have had to release a lease in similar circumstances where somebody was kind of staying there. And in that case, it was a normal kind of Form C release with an affidavit stating that that person had lived there, in this case, for like 10 years or something like that.
When it comes to wills, is there a recommendation to outlining who's the best choice to be an executor or an administrator for your will?
Ideally, somebody in the province and closer to home as possible, but also somebody who's going to be, particularly if there are other children that we're dealing with, if this is a child, that's going to be fair. Going to talk with the other children, has a good relationship with everybody. That's not always possible, but that would be ideal.
I know as the children age as well, the scenario can change. Like, again, from personal experience, I already had somebody lined up when my children were younger. If they needed to be provided for, they had a guardian. But then as they became adults, obviously the next consideration is, should they be in charge of my estate? You know, they're old enough to do it. But my kids, even though my eldest is 27, the child that I chose to help with my estate is actually only 25. And although they're super responsible, I was like, well, that's a lot of decision making for a 25-year-old. And so I aligned it with a close family member that they could work together. And I think I remember on one will revision when I was speaking with Morgan, actually, whoever is in charge of your estate, they actually get paid for some of the job for doing it.
They can. So yeah, I mean, that's a good point as far as it should also be somebody that's somewhat equipped to be doing paperwork, or at least hiring a lawyer to do so, and has some probably financial knowledge, right? So it can be, a child in their 20s, but it just probably depends on the maturity and
Maturity,
what that
responsibility
person is like, right? As far as the fee, they can absolutely claim a fee. It's less common with children, particularly, or I should say beneficiaries, particularly where children are beneficiaries or any other beneficiaries of the will, if they're also executors. Less common for them to claim a fee, primarily because if they're receiving a good portion of the estate, it doesn't normally make sense. The fee is taxable. It'd be considered part of your income. And so if you're going to receive, like, particularly, let's say it's divided between two children and one of them is an executor and they're receiving 50% of the estate, or both of them are, just doesn't make sense. Where it is a family friend, let's say, who's not receiving any of the estate, they may want to be compensated for their time, because being an executor can be a big job. I've had lots of clients coming in for estates that have already done it before and know what a big challenge it can be. So it generally is 2 to 5% the value of the estate. And that depends on how much work they actually have to put in, whether it's a fairly simple estate or quite complicated, those kinds of things.
It's again a trust factor. Like if you live in the interior and you have a family member or friend that's going to be managing your estate, and they live on Vancouver Island and they're missing work and they're taking ferries and driving up and all of that, I'm sure that if they chose to submit a lot of receipts in, that it could start taking away from the inheritance that was meant for your children, your spouse, whoever. So let's move on to powers of attorney and how important those are, especially again, like we normally consider power of attorney with more of an as you age. But I kind of question if just everybody should have a power of attorney, or do we count on that a family member is going to feel comfortable stepping in and making those decisions for you as well? Because truthfully, I'm 50. Something could happen to me tomorrow. I don't know, where I'm incapacitated or can't make my own sound decisions. If a power of attorney was in place, does that save some grievance on your family and help with your wishes, or make sure you receive the care that you wanted for yourself or not wanted?
Right. And I absolutely agree. I think a power of attorney should be done earlier than later, for sure. I get lots of calls actually to the hospital, to care homes, because somebody's had a stroke, or somebody's in the hospital and they're not in a position where they can deal with things. And there may even be a question of whether they have mental capacity at that point. And that can be a real problem for me, because you need to be mentally capable in order to sign a power of attorney.
Me too. I had a call the other day about somebody who wanted to help their mother, who's in their 90s, sell a piece of property. And again, super awkward question, but is she of sound mind? Is she healthy? Can she understand what we're talking about? Who else is going to be there? What's their role? Is there other family that's going to question whether they were forced into this decision? Who's benefiting from the sale? So again, if you don't have anything on paper, or even if you do, like again, as a real estate agent, I deal with powers of attorney quite frequently. Is how long are they valid for? And do you actually have the power to deal with real estate, or is it just for medical care?
No, so power of attorney, there's actually two documents now. So power of attorney, I think it used to all be lumped into one. As long as I've been practicing now, it's been two though. So power of attorney is for financial and legal affairs. It's called a representation agreement is for medical affairs. That's kind of the counterpart to the power of attorney. There's also something called an advanced care directive, and that's probably would be closest to what most people would consider a living will.
Right.
And that's actually stating what your wishes are. The power of attorney and representation agreement are documents that you have in place for while you're alive. So they terminate when you pass, and it's appointing somebody to make decisions and to take care of things for you if you're not able, and that can be because you're not mentally capable, or because you aren't physically capable. As I mentioned, if you've had a stroke, maybe you might still be there mentally, but you can't walk and you're not really in the mind to be dealing with finances and things, right?
A power of attorney can become invalid. So it's like, if I'm dealing with a power of attorney, POA, that has the authority to manage the real estate for the registered owner on title, but during the time that the home is listed, that person passes away, then that POA is no longer valid anymore from, right?
It's you know, if the person appointed as attorney or people pass away, then it's just useless at that point, right? Yeah. You also have to be careful. So to answer your question, there is a clause that we always put in our wills to make sure that can be used for land title purposes. Generally, it's attorney cannot transfer to themselves. That can be something we discuss depending on the circumstances. For estate planning purposes, that might make sense, but for real estate purposes, there normally should be the ability to sell in there. But if you're selling a home, you'd want to make sure, and somebody was wanting to use the power of attorney, you would want to make sure that it has the ability to deal with land listed in it.
That's what we have to ask for.
That normally there's something that will say essentially that there isn't any time limit, something like that, to do that. And then also you want to make sure it's registered, because it has to be registered in a land title office before you can have the attorney sign and transfer form.
Is it just 3 years though that it's valid for, and then it has to be renewed again, or is it 2 years?
Not the way we draft them now.
Is everybody drafting them like that though? Just you?
No, I think most lawyers you go to should, if they're doing their job, probably have a clause in there specifying that it doesn't expire.
So for the realtors that are tuning in and watching, because most of us have been told that POA is only going to be valid from the time it was filed for, I can't remember off the top of my head whether it was 24 months or 3 years, but we can look for
Sorry, I totally misunderstood your question. Okay. I thought you were asking if the power of attorney was void after 3 years. Yeah, registration, you should need to make sure that that's up to date.
Okay, so and that's valid for 2 years? Is it 2 years?
I believe it's 2 years.
Yeah, I think it's 2 years.
I can follow up with you on that, but
okay. So POA can be done at any time. Basically, it doesn't matter if you're 35, 55, or 85. It also goes hand in hand with when you're drawing up a will, to make sure that you have designated somebody that can be responsible for you if you cannot make your own decisions anymore.
And keep in mind, you could get in a car accident at any point and not be able to deal with things, and maybe bills have to be paid, or rent, or what have you, right?
Daycare. Yeah.
Yeah. Right. Like, and if it's not an automatic thing, and your children don't have access, or you don't have joint accounts with your spouse, that can deal with that can be an issue. So
I think people also, and again, we're having other speakers come on in the series. We've got a wealth advisor, and I've got a life insurance broker that will come on as well, because again, these are all tied into your will and what kind of arrangements that you have made. But when it comes into distributing, say, your life insurance to your children, again, if it isn't, I think, registered as there are direct beneficiaries to your life insurance, then I think it also gets held up in your probate.
You have to be careful with that. And I don't often see that side of things. Yeah. So that is definitely more of an investment advisor question, I'd say. But I mean, if they are registered as the beneficiaries on the account and it's done properly, it should flow directly to them. Any assets that aren't, as I said, in jointly held with somebody else, whether they're bank accounts or in joint tenancy on land, or listed as beneficiaries, or have beneficiaries listed, I should say, they will generally fall into the estate, and they're probably going to be held up and having to wait for probate before the individual or executor can access those.
When it comes to being an executor as well, do you have to sign documents in person? You can't you can't sign from a remote location using digital signing or anything? They
Generally
actually,
not.
yeah.
So during COVID, there were a lot of exceptions. And so if there was, for example, I think it would still apply that if you had COVID and you couldn't meet with a notary to sign your affidavits, then you potentially could do it by video. So but there are specific rules that have to be followed, things that have to be put in that affidavit. It's definitely not ideal, and it shouldn't be used just in any circumstances. It should be used if you're medically not able to attend before a notary or lawyer. Otherwise, you're signing affidavits, so they do need to be signed before a notary or lawyer or a commissioner for taking affidavits.
Do sometimes people have more than one POA, like maybe one to deal with health and medical and one to do with the financial side of things? Or
So
can they have two POAs that are working jointly together?
I've seen, it's not common anymore, but I have seen where lawyers in the past have taken out the clause that would revoke any other powers of attorney so that they can do two of them, potentially for different assets, or because they want to have, if you want to have different names on them, if there's an issue with that, because you can only have one name for individuals. I've seen all kind of name issues. As far as the financial and legal versus the healthcare, so a healthcare, that is absolutely quite common because they are different documents. Again, the power of attorney doesn't cover the healthcare. The only thing I have seen a power of attorney cover is acceptance to a long-term care facility, looking into finances to get accepted, those kinds of things. Care homes often ask for the power of attorney. But generally it's not to do with healthcare. The representation agreement is the one that is appointing somebody to make healthcare decisions for you in more limited circumstances. So generally you're going to have to be deemed mentally incapable by a doctor or the healthcare team, or you'd have to be in a coma or something like that where you just can't communicate your wishes. And that can be any healthcare decisions. It doesn't just mean end of life decisions. It means whether you have chemo or kidney dialysis or what have you.
I know when I was putting together some of our talks, because Joe and is it Hisako? Is that how you say her name?
Yes.
That comes out? Yeah. That they're also offering services to to draw up legally binding healthcare agreements now. Would that be similar to the role power of attorney would play in decision making with your health, or is that something to do with more as I age, this is what my wishes are, or I have a family member that's supposed to take care of me and this is how they're being compensated?
Yeah. So to both of, I think the first two, so representation agreements are again the healthcare and a care. This is somebody appointed to make those decisions for me. That's commonly the one we do. There's also something called an advanced care directive. Living wills, a lot of misconceptions around those because it's a kind of a buzzword, like people hear inheritance tax. That's something from the US. We don't have inheritance tax. We also don't have living wills. It's when most people think of that, they think of a healthcare document setting out what their wishes are. We didn't have anything like a living will at that time. So some lawyers would do up documents really just setting out their wishes, but they weren't actually legally binding. Now we have the representation agreement, which is binding. Again, that's appointing somebody to make decisions. And we also have the advanced care directive, which would be binding. I do those very infrequently because they're often doctors, family practitioner will have a similar kind of form you can fill out. It might be a little bit cheaper than what we would probably charge for one. So I normally tell people to go do that. But the idea of that is to, sorry, that was my cat. The idea of that is to set out what your wishes are, particularly and generally for end of life, whether you want to be unplugged, those kinds of things.
Anything else tied to wills that you wish more people would address? We've sort of talked about having one drawn up, whether you think you should have one or not, given you don't own any assets. What about people who don't own any assets and do not have any dependents, but maybe they have debts or something like that? Is that something that should be considered? Or
I mean,
if you don't have,
it depends on the situation, right? If and I should say with any kind of general information I'm giving today or advice, it's all very general. Get your own legal advice if you have.
Didn't I say that at the beginning? This is not meant to be legal advice.
Have a disclaimer on there. But I think, you know, if it literally was a situation where they have no assets and they just have a bunch of debt, probably should have claimed bankruptcy at some point.
Yeah.
The creditors are kind of just out of luck, and there
Yeah.
probably isn't anything to deal with. Maybe the funeral home might be having a bit of a fit because nobody's dealing with that. But if they're a situation I've had, somebody that really didn't have assets, but they were inheriting something from an estate. So something was coming to them and then they passed. And now we need to get letters of administration because they didn't have a will, because their minor child can't receive anything until we have letters of administration for this estate.
Right.
So even if she'd had an executor, that would have made that a little bit simpler, right, to deal with. So things like that.
What about do-it-yourself wills, or just old-fashioned writing your wishes down on a piece of paper? Do people still do that?
Oh, yes. And I have various experiences. I've seen some people and they get the will kits and it's totally fine. Like if you have a situation where everything is joint and you just want everything to go to your spouse and leftovers to the children, and you have a really good will kit, you might be fine, but I generally advise against them. Biggest issues I see are execution. So a will not be valid if it's not witnessed. With two people there and they signed and you signed and ideally it's dated and those kinds of things. And another big concern is that you're not getting any advice when you're doing this. So again, you could have property in joint or tenants in common with somebody else, or you have, sometimes I've had, oh, I want to give this house to so-and-so in the will. And we've talked about this, I guess, today already, but I have so-and-so joint on this. So what are we going to do there? Are we going to transfer it, or we can put it in trust potentially? Like there's different things to talk about there, but you're not getting that advice. And sometimes the situation isn't quite as simple as we think. So I always advise to at least get some advice, even if you're going to do it yourself. I will note though, that if you are doing your own will, most lawyers will not notarize it for you. Big liability for us.
So if you're doing a do-it-yourself will kit, most likely it's not legally binding because it's not notarized and it's probably not filed or registered.
So it doesn't actually have to be registered.
Okay.
So it's a good idea, and with most of our wills we do, but it is optional. With Vital Statistics in Victoria, they have a registry that when somebody passes, you can search and see what wills, if any, they have filed with that registry. They may have wills that aren't filed, so a lot of people don't. And generally we do. So if it's done with a lawyer, most times it will be there. But it's not actually required to be. It's just helpful for your executor or your family members to make sure that they have the latest will, particularly because you have to do the search when somebody passes and it's going through probate. And you have to make sure you have gone through efforts to make sure there isn't a newer will. Sorry, what was the other thing you said? Registration and...
Yeah, that was it. I guess some of my final questions are more like, what documents do people need to bring or have available to have a will drawn up? Do you have a checklist that you usually provide to people to be able to gather the right documents and fill out some answers beforehand before you draft something up?
We have an estate questionnaire that includes kind of all the contact information we need, as well as going through common questions. So do you have specific gifts that you want to make in your will, or vehicles or cash gifts to certain individuals? Who are your good executors going to be? What are the alternates? You should always probably have at least one alternate executor or two co-executors. Where is everything going after that? Do you want any trusts? Do you own a business? Those kinds of questions.
And I'm sure the complexity of those answers or the number of assets will make that will vary in price, but can you say on average, like a general will that's not too complicated, what that would cost somebody?
Generally, so a simple will, we charge $400 plus tax and disbursements. I think it works out to maybe $550 in total with taxes and such. And that's for one. It's $550 for two, so it's a little bit cheaper overall for couples. And those are simple wills. So if we have to do a complex will with a long trust and a blended family situations and lots of different gifts and stuff like that,
or maybe an unincorporated business that you own and how that's going to be handled, like if you're a proprietorship or something.
Yeah,
And sorry, go ahead.
No, I was just going to say, because if you have a corporation, I mean, it's really just the shares that you're holding that are going to fall into the estate. And sometimes that can just fall into the residue and go to your spouse, your children, or what have you, right? But yeah, unincorporated, any assets are probably falling into your estate with that, or a portion of them.
So when somebody does pass and that will gets activated, they obviously get in touch with whoever the lawyer was that drew up that will. And then the probate process starts for the most part. And are you at that time requesting more documents from the executor or the administrator?
Yeah, so we're always looking for, I mean, the will and obviously death certificate. Those are the main ones to start off with. But we need to also any asset information.
Right.
So we need to know if they have property, we need to know if bank statements, those kinds of things. So whenever you're doing a statement of assets and liabilities, which is the document essentially that lists all of the assets and any secured debts in the estate, you have to list what the value was of that asset as of the date of death. And so if you have a bank statement that's from the month that they die, generally go off of that. Otherwise, we're waiting on the banks to get us information for that date of death value. And you mentioned earlier as well, like for real estate, we have reached out to realtors before. You can also, the better way to do it is the market valuation for sure, but a lot of people don't want to pay for that.
Well, so that's interesting because I run into it a few times and sometimes I don't realize until I've done the market evaluation. And so market valuation and tax assessment are two very different things. We know that because when we look at what our BC assessment statement is, and then we have a realtor come out and tell us what our house would sell for in the current conditions, it's probably going to be pretty different. Rural communities, even a further distance apart. This year, don't even ask me because they're all crazy all over the place. But if I go and do a market evaluation on a property and I say, oh yeah, based on the current market conditions, comparable sales, we'll list this house at $650,000 and expect to achieve somewhere pretty close to that. Obviously not multiples now, but still we're going to price it right. But they're going to be paying tax, probate tax on that amount.
So, and so that's why sometimes people want to go with the BC assessment. It's lower. They think, okay, we'll just pay less probate fees. The issue with that is that they're gonna, if they list, they're swearing in that statement of assets and liabilities that value that they're putting there, whether it be BC assessment or received from a realtor or what have you, is the market value of the property. Right. So if they then sell the property, let's say a year later or whatever, even then, and and it's actually way higher because right now the BC assessment's kind of all over the place, quite a bit higher than it was before, but it used to be the case that it was quite a bit lower than what you'd actually receive. So the issue you have there is you're then going to sell it and you're going to have to pay capital gains on that difference.
So that's the issue though, where people don't understand. And so basically, when obviously I ask a lot of questions when I go out to do an evaluation, I have to figure out who's actually asking me these questions, etc. And truthfully, when it comes down to we're selling this property as part of the liquidation of somebody's estate, is they should actually be hiring an appraiser to come out and do a current tax evaluation. And that again is going to be probably different than BC assessment depending on where it is, especially when we get into rural BC, because we've got locations that brand new homes aren't even registered on BC assessment yet, or we've got the wrong picture on the wrong, tax notice. Like it's totally, or we have townhouses that are all the same and somebody's put in $200,000 of updates and somebody's done nothing. It's still the 1960s original, but they're all $500,000. So, again, it's such a case by case. And again, not to get a realtor in trouble by over assessing it in a changing market, because maybe we did an evaluation when it was July 2021 and things were through the roof and they haven't sold it yet. And now all of a sudden I'm having to reevaluate it and it's less. Again, did they pay too much tax on it, or did they not pay enough because they used BC assessment and now they're getting hit with capital gains?
Yeah. No, you have to, it's a real bit of a game trying to
It's an
not,
awareness, right? Who you should
right.
be calling when you're an executor, an executrix, an administrator to deal with the valuation of a property. And as excited as everybody gets, which can also probably cause grief within a family when you've had a realtor come out and said, yeah, the market's hot and we can sell this house, it's in high demand and this is what market value is. But the market changes during the 8 to 12 months until they can actually sell it. And now everybody's all mad and they didn't budget right, or something's, they paid too much tax. So it's another interesting scenario where many people aren't educated in that full process. And yes, like often lawyers do call me like, hey, I have a client that's going through probate dealing with so-and-so's estate. Can you go out and do an evaluation? And then I'm like, oh, before I was like, sure, I'll do it. Yeah, sure, I'll do it. I have no problem. They're free. Like I don't charge any money to have them done. I hope that I get the opportunity to sell the home when probate's done and everything. But now I'm kind of like asking a few more questions about it. Like how long until we're actually selling the house and how are you using this? Because call an appraiser. I don't want to be called into court because I did the wrong kind of assessment on this.
Now we've paid too much probate fees or haven't put it high enough. Now all this capital gains, and it's a bit of a balance.
So maybe just before we go, because I've almost taken up an hour of your time, we'll just plug into that you, Joe, Hisako, all rotate among the Ashcroft office every Tuesday. You guys are there. I think you generally try to be there between 10 and 2, unless there's more appointments or less appointments.
Yeah, we generally keep our calendars open about 10 to 3:30 to 4. Sorry, 10:30 to 4. I think it's about the time. So normally our first appointment is 10:30. We do say, and we have a note on the door as well, that we are by appointment only. So if I only have appointments till 1, I'm normally not going to stick around to 4.
For sure. And so we're doing an open house together because I also share the space with you guys. The office is located in Ashcroft at 203 Railway. So it's right beside the Interior Savings Credit Union. It's between Community Futures and the thrift store. So February 7th, we're doing an open house. All 3 lawyers will be there from 12 to 1:30. Tea, coffee, cookies, I don't know what other kind of snacks, but it will be nice. You guys are all going to do a small presentation, whether it's on business law, wills, power of attorney, health agreements. You guys deal with so much stuff. It's a great time for people to pop in to ask their questions, maybe pick up a questionnaire if they're considering having a will made up. And just pop in. If they want to make an appointment with you, they call the Kamloops office though, right?
Yes, so they should. Well, and there might be a number for Ashcroft as well posted, but it's all transferred to the Kamloops.
Yeah, I've never seen it. So I always give everybody the Kamloops number. It's on the board outside of the office. Anybody can reach out to me if they ever want the number. Same thing, Whitney did her disclosure. You guys get your own independent legal advice for your own situation. I'm a realtor. We always disclose that we're not receiving any gifts, benefits, or referral fees from promoting the services or talking about what Kate's Ford, Epp, and Soll. Did I say it right? Kate's Ford, Soll, and Epp.
Soll and Epp.
I always mix it up. You guys keep changing the name on me.
I know.
Have to offer, but most importantly, like I said, it's my goal to see more supports and services offered in the rural areas so people don't have to travel 1 to 2 hours to meet with a lawyer for things that are so important, like wills, power of attorney, corporations, like you guys did my corporation for me. Again, that will be a topic talk that we have, is the benefits of being incorporated versus just having a sole proprietorship. So again, warm up to come stop in on February 7th from 12 to 1:30. Everybody's welcome. Whitney will be there. I'll be there. Joe and Hisako will be there as well. And I know we have a couple of people here. I'm not watching Facebook Live because I didn't figure I could technically handle all of that at the same time. But if anybody who's in on the Zoom has any questions for Whitney, if they want to ask anything, you can either punch it in the message or talk away. I'm pretty sure I can unmute you. Thanks you for having me, Casey. Yeah, thanks for all the answers. I know I asked tons of questions, but I think it's important, and I think we are able to get lots of good answers and information out there. And I will see you on February 7th.
Okay, I'll see you then.
Okay, take care. Bye-bye, everybody.